Immediately when the court proceedings started, Elias Lukwago asked court not to proceed with a case on grounds that they can't proceed with a case. When the lead lawyer for Dr. Besigye, Martha Kalua, was not in court.
And Section 76 of the Magistrates Courts Act, which reinforces the letter and the spirit of Article 23, is very, very categorical. It's clear that once the accused persons have spent 180 days on remand in matters which are exclusively triable by the High Court, no any other business should be handled by that court except entertaining the application for mandatory bail. And that is the matter we wanted to be addressed on Wednesday this week. Unfortunately, the substantive magistrate who is charged with the handling of this matter was not available. And then there was a stand-in magistrate. We requested him that please accommodate us this week so that we can make that application. First of all, we asked for Thursday. He refused. We pleaded and said probably Friday. He said please, the trial magistrate or the magistrate in conduct of this matter had given him strict instructions to adjourn it to early June. No any other date. It was by compromise that we agreed on 29th of this month. And they indicated that this week there is no date. Or rather, there is no space. They indicated there was no space to accommodate us this week. That was the position of the court. So in a surprise twist of events, last night, they issued the criminal summons or production warrant, rather. They issued production warrant, and shockingly, the state that moved the court to issue production warrant raised a communication which they never shared with us. That is weird. That is irregular. Because as a matter of law, they ought to have served us with a copy of the letter that moved the court to issue the production warrant for today.
Lukwago added that since they were told to come back to court on 29th May 2025 and they were not aware of the reasons why they were in court today, there was no way they could proceed with the matter, apart from hearing the mandatory bail application.
This being a preliminary trial, that is a given, no one is denying it, but even at the level of a preliminary trial, the right to fair hearing is sacrosanct. It cannot be suspended by an overzealous prosecutor in a case that is nothing more than political persecution and judicial harassment of a hero of Uganda. I want to also point number 2 from Section 7 of the Human Rights Enforcement Act, which reinforces Section 76 of the MCA that my senior brother alluded to. And we emphasize there are just a few subsections. Section 7, subsection 1 is succinct, where in any proceedings in a subordinate court, any question arises as the violation of a fundamental right of freedom, the magistrate shall refer the question for determination by the High Court. That is subsection 1. Subsection 2, where a human rights matter arises in any proceeding before a magistrate's court, the court shall immediately stay proceedings in the matter and first determine the human rights issue raised. And especially then subsection 3 relating to the liberty of the accused. A magistrate presiding over proceedings referred to above may stay the proceedings until the reference is determined and may, in the case of a criminal trial, grant bail to the accused person. Of course, 4 says that the court shall dispose of the matter in accordance with what the court says, and the High Court is also given a timeline within which to operate according to subsection 5. So everything points to that today it's only the bail of the accused persons that this court can handle, and that the court's hands are tied. One, to refer the matter to the High Court for fair hearing, and as they refer it, to grant bail in the terms and following Section 76 of the Magistrates Court Act. I will not respond to the whereabouts of the prosecution. Thank you.
However, all prayers were objected by the prosecution on grounds that they had moved court to proceed with the matter, with the issues they were yet to present to court.
Your Worship, just to wind up that, is that the accused persons are ably represented in court. You can imagine this fleet of lawyers, only to claim that the only person who is going to move this court is Martha. Led by senior counsel, one of the best lawyers in town. I grew up admiring, Lord Mayor. There's nothing to refer. The accused person's right to representation is fully guaranteed, as it is in the Constitution. We therefore pray that this court overrules the defense and the prosecution submits as to why this matter was called today. Because we are ready to proceed.
First, I associate with the submissions of Lord Mayor Elias Lukwago and the submissions of Colonel Chiza. The state informed court that it was an agreed position on the 21st. The worship on the 21st of May this month and this year, the sitting magistrate informed court that he only had 2 dates of which he was guided to adjourn his case. That was on the 2nd and the 5th of June. The defense prayed for today. It was the decision of the sitting magistrate that the matter be adjourned to the 29th of May. The state has informed that there is a letter on record. I want to be clear on this, that I do not and we do not have a copy of that letter. My Lord, it is the command still about legal representation and adequate facilities to represent. I don't have the letter. This speaks loud that I do not have adequate facilities for fair representation of A3. It is just fair and in the interest of justice that the matter be adjourned to any other date. But if you incline not to adjourn, actually when they informed me that Ola was coming to court, I thought I was coming to take Ola home. If it is the case, I will be happy to take Ola home. Short of that, Your Worship, I pray that the matter be adjourned to a date where I can adequately prepare to represent Ola today. As it is today, I'm not ready to represent him, for I do not know why we are here. I was ready for the 29th to represent Ola adequately. I submit.
Even up to this particular moment we are speaking right now, we have not seen the contents of that letter. The state is holding it as if it's classified information. So when we raised these issues before the magistrate, we thought they would be serious, rather they would be accorded the seriousness they deserve. We thought the magistrate would grant us that opportunity. First of all, to make the application for mandatory bail. Then surprisingly, no, actually it's not an opportunity. Let me repeat this. We expected the magistrate to comply with the dictates of the law, that before you proceed with any other matter, first consider the application for mandatory bail. That is the law. it came as a shocker to us when the magistrate said, let the state first tell us why we are here. Meaning, even court, which issued the production warrant, wasn't aware why we are here. For us, we could not get to understand the reason why we are here from the state. It is court to tell us. It is court that issued the production warrant. So we felt we were insulted. With all due respect to the chief magistrate, you cannot tell the opposite counsel to tell us the reason why we are here, when actually it is court that summoned us. It's court that issued the production warrant. So even the magistrate was oblivious of the reason as to why we are here. And on that ground, coupled with the fact that our senior colleague was not here, because Martha Karua is the lead counsel. And there is a reason why the accused person took that decision to have Martha Karua as our lead counsel. And we wanted to work out a proper schedule. Because she jetted in on, early this week, and the whole of this week had been reserved for this case. And it's the reason we asked the court, we asked the court, please, can you fix this matter either Thursday or Friday? Can you accommodate us this week? For convenience purposes. But the court insisted that it should be next week. So she had to go back to Nairobi. Now, immediately after she has returned to Nairobi, you issue production warrant. Are you being fair? Are you being just? So this is the, are you being fair or reasonable? So it's the reason we had to withdraw from the bar. And obviously you had the statement from our client. We have not had any opportunity to discuss these matters with them. And it would be very, very unprofessional on our part to proceed under those circumstances. One, where you have no instructions, you have not discussed the matter with the client. Two, you have no idea as to which matter is going to be handled before court, and therefore you are not prepared. Let me tell you, the worst thing a lawyer can do to yourself and your client is to appear before court when you are ill-prepared. So we came here prepared to handle the mandatory bail application, not anything else, because that's the command of the law. Now the magistrate was telling us to go into something else, which was not known to us. So we had to withdraw and wait for the date that was fixed for the mention of this matter. That is 29th of this month, Thursday next week. So that's when we shall be back here.
What is your take on? Prosecution also objected to the allegations that the accused have spent 6 months on remand without committal.
Acknowledge the accused persons appeared before this honorable court on the 21st of February 2025, and today is only the 23rd of May 2025. Yeah. 21st of February 2025, and today is only the 23rd of May 2025. And an arithmetic calculation leads us to a period of 4 months and not the 180 days that our land. My Lord, 3 months and not the 180 days as alluded to by our senior land friend, Honorable Kwame. Your Honor, be that as it may, even if the accused persons had clocked the mandatory period, Section 76 of the Magistrates Courts Act should be read mutatis mutandis, the bail guidelines. And my Lord, according to guideline 9, which I'm going to read out verbatim, mandatory bail for offences triable by High Court and Magistrates Court. Where an offence is triable by the High Court as well as by the subordinate court, if a person has been on remand, my Lord, Your Honor, sorry, it is guideline 10. According to guideline 10, where the offence before this honorable court where the offence is before this honourable court and is triable by the High Court, the application can only be made before a High Court judge and not before you, Your Honour. In other words, the issue of mandatory bail in a capital matter cannot be raised before this honourable court.
It also explains the reason why we had to walk out, because he also appeared to be ill-prepared. He was not seized with the facts. I'm sure when we come back on the Thursday to raise that application, he would not raise that vexatious argument. I don't think he was very serious about it. It would appear he is not in any way informed that actually these people have been on remand since November last year. It would also appear that actually he has not taken time to educate himself about all the matters concerning this case, that it has got a long history from the General Court Martial, which also issued the remand warrants, up to the time when the Supreme Court quashed the proceedings. That is the 31st January. I'm sure he hadn't updated himself about those developments.
Acknowledge the accused persons appeared before this honourable court on the 21st of February 2025, and today is only the 23rd of May 2025. 21st of February 2025, and today is only the 23rd of May 2025. And an arithmetic calculation leads us to a period of 4 months and not the 180 days that our land. My Lord, 3 months and not the 180 days as alluded to by our senior land friend, Honorable Kwame. Your Honor, be that as it may, even if the accused persons had clocked the mandatory period, Section 76 of the Magistrates Courts Act should be read mutatis mutandis, the bail guidelines. And my Lord, according to guideline 9, which I'm going to read out verbatim, mandatory bail for offences triable by High Court and Magistrates Court. Where an offence is triable by the High Court as well as by the subordinate court, if a person has been on remand, my Lord, Your Honor, sorry, it is guideline 10. According to guideline 10, where the offence before this honourable court, where the offence is before this honourable court and is triable by the High Court, the application can only be made before a High Court judge and not before you, Your Honor. In other words, the issue of mandatory bail in a capital matter cannot be raised before this honourable court.
The presiding magistrate, Esther Nyandoi, in giving the ruling, overruled the defence's prayers, allowing prosecution to proceed with its prayers, which ruling was objected by Dr. Besigye.
And the defense have raised several issues and lengthy submissions on the issues raised. The issues raised majorly are in regard to legal representation as provided for under the Constitution. The defense has raised an issue that the two accused persons are represented by who is currently in Nairobi and ought to be here to represent her clients. This court is mindful of the right to legal representation as provided for under the Constitution of Uganda. The accused persons are before court and are ably represented by lawyers, although they state that Counsel Martha Karua is the lead counsel, whereas this court appreciates her role as lead counsel. I believe that the team of lawyers in court present can ably represent the accused in this hearing. This court thus believes that the accused's right to legal representation is guaranteed. This court thus finds no basis to refer the matter to High Court under the Human Rights Enforcement Act. Counsel Kwago has submitted that they are in court today to make an application for release of the accused persons, and as such submissions made by the prosecution are done prematurely. The accused having appeared in court on a production warrant, the prosecution should proceed to make its application or proceed with the production warrant, the reason why it was issued, and thereafter the defense may make the prayers they intend to make in regard to the liberties of the accused persons. This way.
Your Worship, my Lord does not have instructions from us to proceed in the absence of the applicant. I don't know where that leaves us. Because we appointed the Honorable Matthew Karua come from that far. I can compensate the competence, the availability of our current team that we have. But she has a special role to me. That we have had to incur that great cost. Get her here each time. Follow up this case. And as lawyers have immediately pointed out, she was here and we are ready to proceed. Only that it was not really possible. We are now informed, I was informed at 7 p.m. last night that there is a hearing, that the production warrant has been received. Indeed, so our lawyers, some of whom are not here. So, Your Worship, our lawyers definitely don't have instructions from us to proceed in the absence of our.
Basing on the ruling, Dr. Besigye decided to withdraw instructions from his legal team, asking court to proceed with lawyer Martha Karua, or else he abandons the session, with no more options available to them following the withdrawal of the instructions by Dr. Besigye. The lawyers stormed out of court proceedings, although the magistrate attempted to plead with them.
As lawyers, we act on instructions. And instructions have to be specific on what to deal with. And when you receive instructions, you've got to, first of all, have a discussion with your client and agree on what you are going to handle before court. Yesterday, we received a production warrant inviting us here, and we were never given the reason why this session had been organized by court. It's on record on Wednesday when we last appeared, court adjourned the matter to 29 next week. Against our honest and humble plea that please, let's have a very short adjournment, because there were pertinent issues concerning the liberty of our clients who wanted to raise. Those are issues which are canvassed under the Constitution. The issue of mandatory bail. And these are matters of law. We brought to the attention of the court this fact that our clients had spent more than 180 days on remand. And the Constitution commands that once that happens, court has no choice but to release their chosen persons.
Although prosecution proceeded with its prayers, it was hard since the accused Dr. Besigye was not ready to proceed without legal representation. In proceeding, prosecution informed court of their intention to amend the charge sheet. However, Magistrate Esther Nyandoi declined to grant the prayers since the accused Dr. Besigye's legal team was not present.
The 21st of May, 2025. And it was adjourned to 29th. Prosecution moved the court 29th of May 2025. Prosecution moved the court yesterday to have this matter, to have the accused person produced in court. And the reason as to why we made that application is one, that we wanted to, prosecution wishes to make an amendment in the charge sheet, just realign the charges therein, but you should refer to counsel for F3 is in court. Put that on record. So, in the circumstances, Your Worship, we pray that under section 132 of the Magistrates Court Act of 19.
So, you intend to make an application for
Yes,
amendment of the
exactly.
charges?
Exactly.
So, if you intend to make an application for the amendment of the charges, it is only proper that since he says that he has a special attachment to leave Counsel Martha Karua, let Counsel Martha Karua be present when that application is being made. So, that application will be made on 29th May.
How important is it
To-
in the law?
It's criminal conduct. If you are tempted to proceed without instructions, it's not only a professional misconduct, but it is a matter that invites criminal sanctions against you. It's criminal. Do you know the gravity of this matter? The sentence is death. You purport to represent somebody without instructions, or when you are not at all prepared, and inadvertently cause a miscarriage of justice that can lead to execution of somebody, taking away somebody's life, and you take that matter lightly. Not any of us here. For us, we know the implications of the decisions being made here. We know why the state is making all these machinations and maneuvers. We know what they are up to. They want to execute Dr. Besigye. They want to kill him. They have said so. This is a perfunctory process. They are just taking him through a process leading to the gallows. We cannot, would be the last people to escort Dr. Besigye and Obedi Lutale to the gallows.
Nyandoi adjourned the case to 29th May 2025 for mention of the case. However, before court proceedings started, there was chaos and scuffle in court as litigants fought with security operatives who were in plain clothes in court.
She's beating in front of her. You can take snaps. Snaps for what? We are human. Don't shout at her. Because you think you're not tunachifusa kirala kati wabanga z'amatatu yakala tunachifusa kirala tukola bakala n'empisa n'emugala ngenda kwerwanako atuutie makosa. You were here.
We will not accept these people to keep on fighting us, even in court, where we are supposed to appear. They call us in court, and we come for them, they come, ready to beat us and to make sure that they injure us. We entered here, the court was full to capacity. Me, I was happy, I thought they were our supporters. I started filming so that I can update people who haven't reached that some people are already here and we are waiting for court. While I was taking my shot, one of them just hijacked my phone. And now my people had to rescue the phone. In the fight, in the process of rescuing my phone, that's when they started beating them. People have been beaten so badly. We don't know what they come to do in this court, because when we are invited or we are summoned to these courts, we should now be safe in court. What do they come or what do they deploy to do in court? Why? Even last appearance, you saw what happened. While we were going away from court, our people were taken, they were beaten, just taking people to beat them and then you throw them out of the van. They were beaten the whole day until late in the evening when they were thrown on the road. They are now hospitalized, they are in pain. So which kind of country is this? Where should we go? Where should we run to? If we cannot even sit in court where we have been summoned to come. And they come, invade it, they take it over and they start beating us. Why?
Each court appearance, you have jet that wants to feel court. So they come ahead of us in their tents, dressed like civilians. They want to be the one seated in this courtroom. Last time, even the police that is responsible for providing security at court, I think has also been taken over by a judge. Because last time when I was leaving these premises, this police here, the one pretending to be providing security, they are the ones checking my car I was leaving. So really, this is like a military court again. That you have military people who can walk into courtroom and begin beating people. And police is just helpless, just looking on. And one of them leaves court threatening that you will see what will happen to you today. So we can't feel safe in this court anymore. It appears to me that they have now reintroduced the military court, even in civilian courts. Because how did this happen? And police must account for it. You are in charge of court, you are in charge of security. Just walks in, they begin brutalizing people. Last time they kidnapped 2 of our people.
Dr. Besigye, Haji Obedi Lutale, and Captain Olar Charis are facing charges of treason and misprision of treason at Nakawa Chief Magistrates Court.